As a constitutional law attorney, former senior legal advisor and personal counsel to President Donald J. Trump, Jenna Ellis believes in the rule of law and the importance of integrity in our elections. And she's ready to tackle the big cultural and legal issues facing America. This is the Jenna Ellis Show. Here is your host, Jenna Ellis.
Hello, friends, and welcome to another episode of the Jenna Ellis Show. I'm Jenna Ellis, and today the U.S. Supreme Court contemplated the issue of whether or not Joe Biden, as president, had the authority to issue such a broad, wide-sweeping student loan forgiveness package that could result up to the tune of $1 trillion. So a lot of the commentary and the concerns that people have dwelt specifically on the issue of student loan forgiveness, whether or not people agree with the policy, whether they think that this transfer of debt to the taxpayer is fair or not, or whether people say, well, hey, I'm a college graduate. I didn't get what I was promised for my four-year degree, so of course I shouldn't carry this tax burden. But none of those questions actually matter to what the Supreme Court heard today. So what did they hear, and how do we need to think about this constitutionally? That's what we'll discuss right after this. Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook, and I just posted yesterday a really great interview with the president of Legacy Precious Metals, who is discussing why you need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903. All right, so student loans and the issue reaches the United States Supreme Court. So how should we as constitutional conservatives understand this issue? Well, it's not merely a $4 billion question, possibly reaching a $1 trillion question, but it's one of, as Margot Cleveland says in The Federalist, one of grave constitutional dimensions that hides beneath the cryptically named major questions doctrine. So as she describes it here in The Federalist, and I'd encourage everyone to read this article, the Biden administration faces off against a slew of states and two student loan debtors today at the U.S. Supreme Court, hoping to justify its cancellation of some $400 billion in student loans. So much more is at issue, Margot Cleveland writes, however, than the free money giveaway that the president launched shortly before the midterm elections. Our constitutional separations of power is at stake in the twin cases of Biden versus Nebraska and the Department of Education versus Brown. So both of these cases are challenging Joe Biden's Secretary of Education and the Department of Education's plan to cancel the student loan debt that is reaching potentially up to $1 trillion. So how did the Biden administration actually justify this? Well, this was under what was called the HEROES Act. So the HEROES Act granted the Department of Education in the wake of 9/11 to, quote, waive or modify any statutory or regulatory provision applicable to the student assistance programs when the secretary deems it, quote, necessary in connection with a war or other military operation or national emergency, unquote. So because the HEROES Act does include that term national emergency, then the Secretary of the Department of Education then justified canceling student loan debt under the HEROES Act because, as we saw in the aftermath of the COVID pandemic, so many of the blue states and Democrat governors, as well as now Joe Biden's Secretary of Education, are justifying virtually unlimited powers under a so-called declaration of emergency. So basically what they're saying is that because people suffered financial difficulties in the wake of COVID, that this HEROES Act that was passed in the wake of 9/11, so over 20 years ago, that justifies shifting this tax burden and contemplating basically a government spend or forgiveness of close to $1 trillion without the authority of Congress. So the deeper constitutional question here is not just whether or not we like student loan forgiveness or we are opposed to student loan forgiveness. The constitutional question here is, can a member of the federal executive branch justify and make such an important decision as a $400 billion spend on student loan forgiveness without Congress authorizing it, and under a pretext of a so-called national emergency? Now, of course, President Biden did declare and continued to declare a national emergency in the wake of COVID, but did the HEROES Act really genuinely give permission for the Secretary of Education to then make this broad sweeping decision? Well, a handful of red states, as well as several borrowers, do not think so. And that was the challenge at the U.S. Supreme Court today. So they are saying that because the HEROES Act defines the term national emergency, then that will give the pretext for the Department of Education's authority to waive or modify any statutory or regulatory provision applicable to student loan assistance program. So today, when the Biden administration was making their arguments in support, Justice Alito, and interestingly, Justice Roberts as well, was pushing back on this idea that a waiver or modification of the students assistance program is not the same thing as a cancellation. And so modifying or a simple amendment does not, in the statutory scheme, provide this great level of decision-making authority to the Secretary of Education to the tune of a $400 billion spend without the authorization of Congress. So this also led into what's called the major questions doctrine. So under the major questions doctrine, when an administrative agency like the Department of Education claims the power to make these decisions of a, quote, vast economic and political significance, that agency must be able to point to a clear congressional authorization, not this vague provision of, well, you can modify or waive a student loan assistance program or students assistance program just because there has been a declaration of national emergency. So the forgiveness of student loans seems to qualify in a lot of the justices' views in their questioning to the Biden administration as a question of vast economic and political significance. This is really the administrative state that is so overbroadly justifying a huge expenditure and huge decision just under administration and administrative power grab rather than a clearly delineated mandate from Congress. All legislative authority under the U.S. Constitution is given to Congress, and we see that very clearly in Article 1, Section 1 of the U.S. Constitution. The rise of the administrative state has really started with the so-called Chevron deference, which is, of course, another Supreme Court case about 50 years ago that suggested and stood for the proposition that basically the agency that is mandated with fulfilling the legislative directive from Congress can fill in the details. And so legislation doesn't have to be overly burdensome to literally command every jot and tittle of how the executive agency fulfills that provision. But what Chevron deference has become and has given rise to a vast administrative state that is looking to just pretext and proof text a lot of these legislative prerogatives and saying, well, just because now, the HEROES Act in the wake of 9/11 says that we can modify or waive student assistance programs, then simply because there's been a declaration of national emergency, then that will now justify an expenditure of $400 billion. That it has huge economic significance, and it also has huge significance on whether or not the administrative state can simply power grab. The major questions doctrine is incredibly important, and these twin cases are vastly more important than just the issue of student loan forgiveness, when the justices hopefully will give clarification and guidance to future executive authorities who are going beyond the scope of what legislation originally intended. If student loan forgiveness was actually something that Congress intended, then Congress needed to pass that bill. And Nancy Pelosi, interestingly enough, said that exact thing when she was talking about student loan forgiveness and said that Joe Biden did not have authority. She said that back in 2021, and she even said that this needs to be an act of Congress. So when you have the then Speaker of the House in your own party saying this is a bridge too far, when it is the Democrats who are always on the activist side and power grabbing side, when Nancy Pelosi is saying this is a violation of the separation of powers and wanting to make sure that she retains congressional legislative authority, I think the Supreme Court needs to stand up and pay attention. And from what I heard in the oral arguments today, it does seem like the court is poised to do that. And I think that these cases can really lay a lot of significant groundwork to diminish the impact of an overreaching administrative state that Justice Gorsuch has railed against, rightly so, for years. This is a wonderful opportunity, and I would love to see him write the majority opinion here in this case that will erode the administrative state from basically weaponizing legislative authority and running away with it. So here's what Justice Gorsuch actually addressed when the court last addressed the major questions doctrine. So in concurrence joined by Justice Alito, they noted that the doctrine, quote, operates to protect foundational constitutional guarantees and to protect the Constitution's separation of powers. So Article 1, Justice Gorsuch stressed that the people vested all of federal legislative powers in Congress. So the important subjects, he writes, must be entirely regulated by the legislature itself, even if Congress may leave the executive to act under such general provisions to fill up the details. He's talking about Chevron deference. So the concurrence also continued by saying, quote, the Constitution's rule vesting federal legislative power in Congress is vital to the integrity and maintenance of the system of government ordained by the Constitution. Vital because the framers believed that a republic, a thing of the people, would be more likely to enact just laws than a regime administered by a ruling class of largely unaccountable ministers. This is perfectly articulated. And again, I would absolutely love to see Justice Gorsuch write the majority opinion for these cases on this issue of federal student loan forgiveness. And we have to, as conservatives, make sure that we are not just arguing the policy issues. I've seen the hashtag all day trending, student loan forgiveness, and a vast majority of leftists, but even conservative voices as well, are only debating the policy consideration. That's appropriate in front of Congress, but Congress is contemplating no such forgiveness legislation. This is all about a runaway executive. So even if you like the student loan forgiveness plan, even if you like it, the constitutional question is, can the executive branch do it? And the simple and constitutional answer to that is no. So we need to, as conservatives, always make sure that we are conserving not only limited powers of the federal government and even the states, but limiting the federal government to their enumerated powers and separating those powers in their right branches. So if we look at the U.S. Constitution, the Department of Education is actually not even a constitutional agency to begin with. So we have just continued to snowball this entire problem of the federal government being an overarching massive behemoth in Washington, D.C. But for this particular issue in front of the U.S. Supreme Court, it is incredibly important that we commit that the province of the legislature is to determine whether or not they would choose to grant such a wide, broad, extensive cancellation policy. It's not just a waiver or a modification. And that question was particularly apt in the oral arguments today. This isn't just a modification, it's an entire cancellation to the tune of almost $1 trillion. That is the province of Congress to determine, not Joe Biden. So remember, when you're engaging in these types of political questions and these constitutional questions, debate the policy all you want, but make sure that the threshold question is always asked. Does the executive branch, whether it's Joe Biden, Donald Trump, anyone else, does the executive branch or the agency of the executive branch have the authority for the act or the policy that we're even discussing? And if the answer to that is no, which in this instance it is, then why are we even debating the policy? Say, you know what, go to Congress. Justice Sotomayor, if you really like a student loan forgiveness plan, well, then get off the bench, run for Congress, right? That's why our founders, in their wisdom, limited powers, but also separated them. So a violation of the separation of powers has really been generated for so many years through a vastly encroaching and vastly expanding administrative state. I hope that the Supreme Court will do the right thing. I think that they will, but definitely stay tuned. We'll have more on this when the Supreme Court does issue their opinions in these twin cases. But for now, definitely wanted to provide you insight onto how this question at the Supreme Court actually needs to be broken down. Because remember, not about the policy, all about the constitutional question. Can the government, not should the government? Legacy Precious Metals is the company that I trust to give you good and patient counsel for investing in your retirement. The Biden administration has caused a financial crisis, and they have no clue how to fix it. Oil prices have skyrocketed, and when oil prices go up, not only do your expenses go up, but the cost of transportation and shipping spikes, leading the prices of goods to rise. And we are already seeing record inflation. That's the last thing that we need. Our economy is in trouble, and you need to take steps to protect yourself. If all your money is tied up in stocks, bonds, and traditional markets, you may be vulnerable. So gold is one of the very best ways to protect your retirement. No matter what happens, you own your own gold. It's real, it's physical, and it's always been valuable since the dawn of time. Call Legacy Precious Metals today at 866-528-1903 or visit them online at legacypminvestments.com. That's legacypminvestments.com, where you can download the free investor's guide. You can also go to my Facebook page, Jenna Ellis. I am a public figure on Facebook. You need to start your retirement account even if you're in your 20s or 30s. There is always a great time to protect your retirement and invest, just like you want to protect your health over the long term. So go to Legacy Precious Metals at legacypminvestments.com or call 866-528-1903.
Have you ever picked up a towel set because it felt so soft in the store, but then when you leave and you go to use it, it's not really that absorbent? It's basically a towel that is leaving you out to dry. That's why MyPillow has developed the MyPillow towels that actually work. I know, it's totally mind-blowing. Towels that actually dry you. Their 6-piece towel set includes 2 bath towels, 2 hand towels, and 2 washcloths. They come in a variety of colors. I have the sage green and the white. I love them. And right now you can receive a 6-piece set for only $39.98 with promo code Jenna. That's Jenna. So go to mypillow.com right now and click on the radio listeners special. MyPillow products come with a 10-year warranty and have a 60-day money-back guarantee. So to receive this amazing offer on the 6-piece towel set of MyPillow towels, just go to mypillow.com, click on the radio listener special, and enter promo code Jenna, that's Jenna, or call 1-800-564-8475. That's mypillow.com, promo code Jenna.